The labor unions include the Ghana Health Service and the Ghana Education Service. They declared a 2-week strike over government's decision to appoint a trust manager for their Tier 2 pension funds. The workers were forced to terminate the strike following a court order secured ex parte by government in a bid to stop the workers from carrying out their threat to resume the strike action if their demands were not met. Now, the government proceeded to court to challenge the decision of the workers to go on strike and to apply for an injunction against a possible strike by the workers. Now, having thoroughly assessed the arguments by the Deputy Attorney General, Dominic Ayini, and that of Godfred Dami, counsel for the workers, the judge ruled in favor of the government. Now, joining me online is Deputy General Secretary of the Ghana Medical Association, Justice Youngson. Oh, I'm told we're still trying to get him online, but we're looking at the issues that were raised today at the court, talking about the labor union, 12 labor unions that want to go on strike. The issue is that government asked them to get away from their strike, come back, let's negotiate, only for government to pass back and go to court and ask them now not to go to court, not to go on strike. It's a matter of slapping me and asking me not to cry. We'll be getting a labor consultant to talk on this matter. We'll also be getting members of the union on board to also express their feelings, and we'll be talking to a lawyer to give us a legal dimension of all of this. We'll take a short break on today's big story. So 12 labor unions seeking to go on strike because their demands have not been met by government have been asked not to go on that strike because the court has put an injunction on that strike. In the studio with me right now is a labor consultant and he's also ADR practitioner. His name is Ben Arthur to dissect this ruling. Good evening, sir. Thanks for joining me.
Good evening, madam.
So Ben, let's look at the ruling today. I know you have been following that issue. Tell me, what do you make of the ruling?
For me, it speaks volumes, but because of your limited time here, let me just touch on two of them. It seeks to undermine a basic principle at the workplace, what we call the principles of the freedom to strike, and then not just the strike, lockout. You know, employers can also embark on strike, but their equivalent of strike is called lockout. These are basic principles universally accepted worldwide for employers and employees to drum home their demands and to protect their interests, which is also enshrined in our constitution, for workers to have the freedom to join trade unions and to promote their interests in socioeconomic spheres. So these are basic principles that I think we have to uphold. The judgment, to me, in particular as a labor practitioner, seeks to speak to me that, look, you are not entitled to strike. And what makes it a bit limited, in my opinion, is that it speaks of the opportunity probably not to strike some other time, but we should know that we are dealing with a volatile situation. If we are dealing with labor or employers, for example, you ought to consider three things. You ought to consider the power behind the people. You have to look at their values at the workplace. You must also look at the work environment. Yes, they might be limited in going on strike because of court ruling, but nothing bars them from going on processions and demonstrations, which already some of the labor people are speaking of. These are alternatives to them. So if we are not careful, they will go on strike on another matter. Because this is a particular matter that they have gone on strike. There has been a ruling, so they are restrained. But they could go on strike on an ancillary matter. So we have to really sit down and deal with the situation. There's also a concept in industrial relations. We call it the power approach. It looks as if in Ghana, instead of looking at the consensus and the third party, interventions in resolving disputes, we like the power approach, which is to go for arbitration or to go for, let's say, litigation.
So if I heard you right, in this ruling, these three important things you mentioned did not come into.
They seek, in my opinion, it looks as if it's a bit undermined. And if we are not careful, what normally happens, the trend is that labor goes home, they re-strategize, they don't come back on strike, they go on demonstrations, which I don't think there's any ruling anywhere in Ghana that bars people from demonstrating. So we have to look at the core issues. The next question to ask is that, would they not be entitled to go on strike another time on another issue? What if this issue stays unresolved for the next 1 year, 2 years or more? Are workers going to sit down and wait? However, I must be particular about this, that under the labor law, we have certain groups of people who are not allowed to go on strike, and we call them essential services, those in the essential services sector. For me, the name is a bit inappropriate. Let me call it those under emergency services, the health services, those working in the utility companies, oil and gas, sanitation, security, and the rest. They are not entitled to strike at all under our labor laws. For ruling on those particular ones, it looks straightforward.
We've been trying to reach members of the union to talk about this issue, but we're not getting them. But let me go back to you and look at the Supreme Court ruling, the ruling today.
Yes,
and the judge was saying that in his ruling, he said it is only the Supreme Court that can interpret whether or not the right to strike is guaranteed by the Constitution. And so it's something that brings us back and forth. We go back and forth with it, that are they entitled to strikes or are they not? What does the Constitution say about strikes in general?
It's a smart move on the judge not to have made pronouncement on that, because it falls under the authority or the jurisdiction of the Supreme Court to make interpretations as to what the Constitution has. But to me, as a labor management practitioner, workers are entitled to strike. The matter has not gone to court yet, or to the Supreme Court, so let me be free and comment on it. And I can cite relevant articles. Not only that, we have also ratified ILO conventions that entitle workers to go on strike. And the point is, if you take industrial relations and you take lockout and strike out, what it means is that I have the opportunity to slap you, but I will tell you that don't cry, or I will restrain you from crying. So for people to cry, and it's not only strike, we also have what we call picketing, where workers, aggrieved workers, can within a perimeter of 10 meters surround their workplace and even resist customers from coming in. And strike takes various forms. That's one thing we should know. What's the definition of strike? The labor law has a definition of strike. We have sit down strike, the people will go to work, but they won't produce.
Let me hold you on and let me pick the labor lecturer at the University of Professional Studies. His name is Godwin Adagawini, for his thoughts on this matter. Good evening, sir, and thanks for your time.
Good evening.
We've been talking the injunction placed on the 12 labor unions that seek to go on strike because their demands have not been met by government. Do you think the approach adopted by the Council for the Labor Union today was appropriate?
You mean their approach by going to court or some other approach?
The approach in handling the whole issue. I mean the council for the union.
Well, I am unable to comment on their approach, but if you are looking at the ruling of the court.
What do you make of it, briefly?
Yeah, the point is, as it is stated, that if the labor unions were to be allowed to go on strike, especially indefinitely, that could grind government machinery to a halt. And in that sense, one will see the judgment as being reasonable. But there are other contentious issues also contained in the judgment. For example, about whether or not the right to strike.
But if we look at it as in the right direction, that it will halt government machinery, shouldn't we also care about the workers?
We should care about the workers, but the ruling doesn't mean that the society or the state doesn't care about workers. I think it is in the interest of workers and everybody that the machinery of government doesn't grind to a halt. I mean, for example, if doctors don't go to work, I mean, and somebody working in another sector who, I mean, and gets sick and goes to the hospital and there's nobody to attend to him, what happens? So looking at it from that point of view, we would not say that the judgment can properly be interpreted as to suggest.
But shouldn't that also,
the interests of workers are not being taken care of?
Shouldn't that also push government to understand that these people are very important, and so their demands or their needs must be catered for, so they can also deliver in equal manner?
Yes. In terms of the role that workers play, I do not think that anybody disputes the importance of that role. What is happening is a disagreement over an issue, and the matter is before the courts, which are the appropriate place where these disagreements will be resolved. So we should be patient for the courts to resolve the issue. But of course, delaying in disposing of the matter will also raise serious issues of concern. So I'll agree with you to the extent that you made the suggestion that a speedy resolution of the issue is very important. But beyond that, I will not agree with the view that the judgment seeks to undermine or belittle the importance of workers, especially in the public sector.
There have been some arguments over what the law says about essential and non-essential service providers. I want to say emergency and non-emergency service provider. I think it sounds better. What does the law say about that?
Oh, the Labor Act specifies certain services as essential services. And the concept of essential services simply means that those services, the provision of those services must not be interrupted by any industrial action, because that will cause serious inconvenience to the general public. So that is what the law says. And if you are engaged as a worker in an undertaking that provides those services, under the Labor Act, your right to strike is taken off, and you cannot embark upon a strike action.
Let me play the devil's advocate, and let's look at the critical role that the Labour Commission in such matters is supposed to do. And looking at how far the matter has gone, did you envisage that this issue will be protracted to this level? And does this mean that the Labour Commission has failed?
Well, the Labour Commission is not the only organization that is to contribute to the resolution of industrial disputes. The parties to the dispute, namely employers and workers, and the Labour Commission, are enjoined to play their respective roles in a manner that will contribute to the effective and peaceful and meaningful resolution of industrial disputes. So if the parties to the dispute do not cooperate, there is very little the Labour Commission can do if we are looking at it from the perspective of an effective resolution of the dispute. But the Labour Commission can only do what it can do.
I'll hold you on there because I have Mr. Ben Arthur in the studio with me, and I'll pick his thoughts briefly on this issue, that the Labour Commission is supposed to play a very key role in resolving matters between labour unions and the government. And this is the case where government says, come back from your strike, let's negotiate and see how we can resolve this issue amicably. And then government now takes you to court and put an injunction on your strike. Do you think the Labour Commission has done justice, or have they failed in their mandate?
I will not be quick in pronouncing judgment on whether Labour Commission has failed or not. But as I was mentioning earlier on the power issues, what in Ghana the public sector workers see National Labour Commission to portray is that it portrays more of the power argument than the amicable settlement. And so if National Labour Commission, who is supposed to be an umpire, the third party in this tripartite kind of system, If National Labour Commission itself has the right to go to court and is supposed to intervene in my case and listen to my details and all my confidential issues and can also go to court, people shy away from the National Labour Commission because they see it as a quasi-court. So why don't you go to court? So to a great extent, National Labour Commission is failing from that angle. Apart from that, I believe the time has come to look at the National Labour Commission as an institution, because if you look at even the qualifications for being on the National Labour Commission, which says that you shouldn't hold any executive position in a political party, you should simply understand industrial law. It's woefully inadequate in handling labor dispute. Apart from that, I'm also of the opinion that National Labour Commission is heavily under-resourced. If we have a lot of labor agitations or disputes in, let's say, Tamale, Kumasi, where is our labor office there? It's basically concentrated in Accra. So the spread is also another thing that we ought to look at. We have to look at the employment of the commissioners. They are part-time workers. And sometimes I dare say that they don't form a quorum. So these are big, big issues that we have to tackle. But by and large, I think they are doing their best, only that it is not enough. If I may comment on what my colleague had said earlier on, then the labor law allows strike. But when it comes to the essential services, it doesn't give them any room for strike at all. And the Constitution, under Articles 24, I'm not a constitutional lawyer, I'm not a Supreme Court judge, but by practice, under Articles 24, the Constitution allows citizens and people to form unions, freedom of associations, and to protect their socio-economic rights. Under under Article 24, Clause 4, it seeks to restrict the protection of those interests by way of strikes and the rest, by saying that where we have national security priorities, where we have public order interests, where we have the protection of the rights and freedom of others being infringed on, then we have to exercise discretion in this direction. So nothing actually bars people from embarking on strike. If we take it out, people might not even go on strike anymore. The next thing we know is that people are burning, houses, they are burning workplaces and the rest.
To register
in protest. We have had it before.
I
the colonial
have with
days.
me a member of the union, his Deputy General Secretary of the Ghana Medical Association, Justice Yankson. Good evening, Justice. Thanks for joining me.
Hi, good evening.
I know you are unhappy about the ruling, but tell me, why do you think the ruling should have been in your favor?
Well, for me, as a member of the legal team, I mean, naturally, every lawyer goes to court expecting to be successful, or victorious. So if I'm to look at it on that basis, then you may say I'm not happy. But on the other breath, the issues are very simple. One party will have to win. And the judge gave some reasons for what he did today, i.e. for public, policy considerations. He thought that it was just and convenient to grant the Attorney General and government, for that matter, what the application sought to achieve. I mean, in law, this is fair, but then, as lawyers, we also reserve the right to appeal as and when we think it is necessary. So, for now, yes, as we said, or we indicated in court, we are obliged by whatever has been said today. We'll wait for the formal written, ruling from the judge. We'll have a look at it. And if there's any need to exercise our right of appeal, we'll do that. Otherwise, no problem, because after all, the workers are already working anyway. The workers are not on strike. So if they continue to work, I don't see any big deal. But what ought to be made clear is that this injunction was specific. It had to do with matters related to Tier 2 as brought before the court at this moment. That doesn't mean that it takes away the rights of workers, for instance, to embark on some action other than issues to do with Tier 2. I mean, they still have the right to exercise it. Except to add a bit to what my colleague on the other side just said a few minutes back. He this bit about the Labor Act giving, in quotes, essential services no right to go on strike, I think people sometimes will need to look at things in the proper manner. See, the employment contract is one of service, not servitude. And that is why in the wisdom of the Act itself, it says that if you are going to more or less take the right of essential service providers to go on strike, issues that actually affect them as and when they come up, you need to resolve them within certain time limits. Stretch it, we are talking about maximum a month. So if in situations where government wants to hide behind this and in quote, decide not to resolve the issues, and then for periods sometimes spanning 2 years to 3 years, these have not been resolved, I don't think in the proper interpretation we will say that the workers will not have any right at all to embark on some action for their legitimate demand. That is the position of some of us, because then you are turning the employment contract into one of servitude, and that is not what the labor law speaks to do. So anytime people talk about this clause that essential service workers in quotes do not have a right to go, I think it will be just fair that they add the caveat, the other rules that say that, look, you have to sort their issues within a certain time frame. And that is the more reason why you want to take a right that is guaranteed for all other workers away from essential service workers. If you don't do that, then it means you are being unfair to some citizens of the state.
So in case this appeal thing doesn't work, does it mean that you workers will keep on working without saying a word about the Tier 2 pension?
No, it is not like that. The issue is that the matters are now before the court. So we all expect the court to do its work. And the court is saying that for now, in quote, don't go on strike whilst I determine these issues. Definitely there ought to be a determination at some point. So assuming, without admitting though, that the unions decide that, together with the lawyers, of course, decide that there is no need for an appeal, what it means is that the workers are going to go keep working, except that they are not going to go on any strike specifically on Tier 2, as the issues stand before the court. But then, for me, it is nothing new, assuming that is even the position. The workers are already at work. As we speak, all of them were to work today. And even before the injunction, the last 1 month, they've been at work. So technically speaking, yes, the injunction is there, which will restrain them. But I don't think it has really changed much.
Well, many thanks to you, Justice Youngson, for your comments on this issue. Let me go back to lawyer Adakawini and I'll ask you, now we know that workers are not supposed to go on strike. We only know that it's people who offer essential services that have certain limitations. So let's look at international conventions. What do they also talk about? Hello, lawyer.
Yeah, hi, this is Dr. Youngson.
Hello. Oh, Mr. Youngson. Hello, lawyer Adakawini. I think we lost him online. Let me come back to you and let's look at international conventions, because now we know that nothing restricts workers from going on strike. And so what does the international conventions talk about on labor?
Let me state that there's nothing like nothing restricts or prevents workers from going on strike. There's what we call legal or illegal strike. So what has basically been said by the judgment is that that strike is more or less illegal.
Okay.
So workers are entitled to go on strike. But under Ghana's labor law, which is International Labour Organization compliant, ILO compliant, what it seeks to do is that for emergency services, if people are going to go on strike, like water, like in the health services, what it means is that your grievances, if people lose their lives, at the end of the day, what happens? But just like my earlier colleague said, we have limited days within which to settle differences at the workplace involving these sectors. And if you have the time, let me just read one of them.
Briefly.
Section 162 of the Labour Act, 651. In any industrial dispute that affects workers engaged in an essential service, the parties to the dispute shall endeavor to settle the dispute within 3 days of the occurrence of the dispute by negotiation. That's the first one. Subsection 2. If after the expiration of the 3 days the dispute remains unresolved, the parties shall within 24 hours of the expiry of the 3 days refer the dispute to the commission, which is the Labour Commission, for settlement by compulsory arbitration under Section 164. Then the last one, the commission shall take immediate steps, but not later than 3 days after the dispute has been referred to it, to settle the dispute by compulsory arbitration.
But in all of these, shouldn't we as a country be thinking of how to end this whole labor union agitations?
What has happened under the section that I've read to you is that when it comes to the essential services, sometimes, just like the earlier, I've forgotten his name, the last speaker mentioned, that sometimes the limitations of the days go beyond it and people get really frustrated. They don't know which other alternative to take to get the matter resolved. So they resort to strike, but it doesn't have to be so. And 163 actually speaks about the prohibition of strikes in any matter when it comes to the essential services. That's what the law says. However, in practice, people don't have an option out. So if there are delays, and I think that people sometimes hide behind the bureaucracies, so when there are excessive delays and it goes beyond the limits of their patience, I mean workers' patience, then they resort to strike. But I'm telling you, they know that this is the position of the law.
Well, that's all time will allow us. This has been today's big story. Jay and I will be in shortly with Marian Ture.